Call on Government Order of the Day number 1.
Prisoners and Victims Claims 2012 Expiry and Applications Date Amendment Bill, first reading.
I call the Honourable Minister, Judith Collins.
Mr. Speaker, I move that the Prisoners and Victims Claims 2012 Expiry and Application Dates Amendment Bill be now read for the first time. I nominate the Justice and Electoral Committee to consider the bill. At the appropriate time, I intend to move that the committee reports back to the House finally on or before the 11th of June 2012, and that the committee have the authority to meet at any time while the House is sitting, except during oral questions, during any evening on a day in which there has been a sitting of the House, and on a Friday in a week in which there has been a sitting of the House, and outside the Wellington area during a sitting of the House, despite Standing Orders 188, 190A and 1911B and C. The Prisoners and Victims Claims Act 2005, passed by the previous Labour government, ensures that awards of financial compensation are only made to prisoners in extraordinary circumstances, where no other remedy is deemed appropriate. Prisoners are required to make use of the many existing complaint mechanisms that are available to them before they seek compensation through the courts. If financial compensation must be awarded, the Act requires that deductions are made first by the Secretary for Justice to pay legal aid debts, reparation and earlier orders in favour of victims. The Act then allows victims of the prisoner to claim against the money through a simplified victims' claims process. The Act contains 2 sunset clauses that are due to take effect on 1 July 2012. The sunset clauses are effectively expiry dates for the Act. The first sunset clause provides for the expiry of the restrictions on awards of compensation. The second provides a cut-off date for compensation awarded to prisoners to be subject to the deductions and victims' claims process. This bill extends the application of the Act for 1 year. The sunset clauses are amended so that they will now take effect on 1 July 2013. The bill will bridge the gap between the expiry of the current Act and progressing the government's policy to redirect prisoner compensation to fund services for victims. The government's policy to redirect compensation requires any prisoner compensation remaining after the victim's claim process is used to fund services and programs for victims of crime. The existing victims' claim process will also be made permanent. The legislation to make the Act permanent and to implement the government's redirection policy is currently before Parliament. However, there is insufficient time for that legislation to pass through its stages before the imminent expiry of the current regime on 30 June. I also believe that it is important for that redirection bill to be fully considered by the Select Committee before it is passed. It is important that there is adequate time for all members of the public who want to have their say, and for as much cross-party support as possible, and I intend to fully consult with other parties in Parliament as to how that might happen. If the current Act expires before the redirection bill comes into effect, a window of opportunity would be created that would mean that the restrictions on awards of compensation, the deductions in the simplified victims' claims process do not apply to any prisoners' claims that are lodged. There would be a clear incentive for potential claimants to file their claims during this window to try to defeat the purpose of the current regime and the future redirection regime. The new bill will prevent the unfair window of opportunity occurring that would disadvantage victims of crime. To ensure the status quo and the laws governing prisoner compensation, it is important that this bill be considered promptly by a Select Committee and reported back to this House by 11 June 2012 so that it can be in effect by 30 June. The new bill maintains the status quo until we implement our redirection policy later this year. It will ensure that the current restrictions on awards and deductions continue. It will also ensure that victims continue to have access to any financial compensation awarded to prisoners. I commend this bill to the House.
The question is that the motion be agreed to. I call the Honourable Member, Charles Chevelle.
Thank you, Mr Speaker. Mr Speaker, I'm going to take a short call to respond to what the Minister has just told the House. I think the first thing that it's important to say is that the substantive legislation responded to at least a perceived need at the time. But clearly it was an experimental piece of legislation, and if the House needs any evidence for that, in addition to the speeches that were given at the time concerning what is now the Act, then it simply needs to look at the fact that a sunset clause was applied to that legislation. And clearly the House's intention was that there would be a review of whether or not the substantive Act had merit and whether or not it was required to continue past the date of the sunset clause, either in full or with modification based on experience with the legislation. Well, it is instructive to look at experience with the legislation. There's a special procedure set out under the Act for victims' claims in the particular context that this Act deals with. And in response to a written question from me, the Minister's Office has indicated that that procedure has been invoked precisely one time, on one occasion, since the Act came into force. So it has to be said that the case for the Act is, or has proved to be, despite the apparent need at the time for some sort of measure, somewhat questionable. Now, I have some sympathy for the position that the Minister is in, clearly because there was a sunset clause expressed in the Principal Act. It was intended that there should be a review of the Act prior to us getting anywhere near the date that the sunset clause would be triggered. But no review was commissioned by the government. And I think that I don't need to say anything about what that says about the record of the Minister's predecessor and his conduct of the portfolio. We are where we are. The review was not commenced, and now the sunset clause is about to take effect. So the question is, what ought Parliament to do? There are a couple of alternatives. We could allow the Act to expire and review the situation to which it applies. Consider whether or not special legislation is required and apply it, or simply allow the Act to fall into abeyance. Or we could do what the Minister proposes, which is to extend the existing legislation for a period of time and allow the review to take place that should have been commissioned a good year or so ago to now occur. The Minister's consulted me. She's given me some assurances in writing about the short period of time for which there will be an extension of the legislation. And I've said to her, I agree that the position is such that we ought to allow the legislation to remain in force for a short period of time, that is another year, and during the course of that year we ought to conduct the review that should have been conducted. And that is what I propose certainly members on this side of the House will follow as a course of action. I am concerned that the Minister feels that it's necessary for this particular piece of procedural legislation to be referred to the Justice and Electoral Committee for a very, very short period of time, and for leave to be sought from the House for the committee to meet at all times except during question time. The committee is capable, I think, of managing its own business without that sort of leave from the House. I see that the chair of the committee is here and I'll be interested in his views later in the debate. But given that at least the principal opposition party has signalled to the government that we will cooperate in respect of this matter, those sort of expediting resolutions which, as we know, can be applied in a heavy-handed way and which circumvent the freedom of our committee system to conduct itself in the way that it should, are undesirable. And I'm disappointed that although the Minister was prepared to consult about a number of issues, she didn't see fit to disclose that it was her intention to have the committee directed by the House in the way that she has. So, Sir, that's really what I want to say about this legislation. There needs to be a review. That was always the intention of the original Act. It is an indictment on the government that, notwithstanding that they've been in office for over 3 years, that review was not conducted. But it does need to happen now, and we will facilitate participation in that review. We think it's an important exercise, and we think that it's important to listen to all sides of the debate as to the question of what ought to, if anything, replace the prisoners' victims' claims legislation. Thank you, Mr. Speaker.
I call Tim McIndoe.